Good evening to the participant of the JCJ 2022, the main examination, which is going to be held on 26 November 2022, if it is not postponed over there. Participants, anyone can unmute and read that what I posted on the screen.
Welcome to the participants of JCJ 2022 Me-12-11-2022. Stages of a civil suit. Presentation of plaint, issue and service of summons on defendant, appearance of parties, ex parte degree, filing of written statement by the defendant, production of documents by the parties, examination of parties, framing of issues by the court, summoning and attendance of witness, hearing of suit and examination of witness, arguments, judgment, preparation of degree, execution of degree.
Yes.
Professor Dr. Mohammed Saheb Hussain, Professor of Law, South Mazwana, Tanzania.
South, S-A-U-T, South, Mwanza, Tanzania. So these are the stages of the civil suit is concerned. Then what comes first? Judgment comes first. Next.
Degree.
Then execution of a decree.
Yes, sir.
Yes, in my last class, we are dealing up to the powers of the transferee court. We are dealing at the time. Under Order 21, Rule 8 of the Code, if a decree under the provision of the Section 39 has been sent for execution to another district, it may be executed by either the district court to which it was sent or by a subordinate court which has competent jurisdiction to which the district court may refer it. So under the 21, it is Rule 8, it is made very clear when it forwards the Section 39 is there for the execution of another district. So either the district court to which it was sent, it will make it out, or by a subordinate court which has competent jurisdiction to which the district court may refer it. Either it can be conducted with the district court or the district court may direct the subordinate court to do so. Is it clear?
Yes, sir.
There is no such a hitch. Now let us see the section 42 is concerned, provides for the powers of the transferee court and states that the court to which the decree has been sent for execution shall have the same powers in the execution of such a decree as if it had been passed by itself. Even though the court which did not pass the decree, but it is assigned by the district court to execute it, it is having the same powers as if fill the blank.
It is passed by its own.
Yeah, as if it is passed by the same court. So the court has the power to punish the persons who cause obstructions in the execution of the decree, and the power shall be exercised by the court as if the decree has been passed by it. Even the punishment also. In the execution, if somebody make the obstruction, it will punish the obstruction that who made the impediment as if that the same court has passed such a decree. The main object of giving such a powers to the transferee court is to ensure that the judgment debtor pays the money or gives such other things to the decree holder as would be directed by the decree. Why such a power it would be given to that court? Because the judgment debtor should have to pay the entire amount to the decree holder as would be directed by the decree. What it is stated in the decree, that in total would be implemented. Shall I proceed further? Say yes.
Yes.
Good. The court will have the following powers. Namely, what is the Latin terminology for the namely?
That is, sir, IE.
Wrong. At a stay, that is, here namely I said, but I already told. Namely, what do you say? Vidilicet means V-I-Z. That is namely. But actually full form is, see, read. Read what I posted on the screen.
The abbreviation viz or viz without a full stop is a short for the Latin videlicet.
Videlicet. Videlicet. Videlicet. Which?
Videlicet, which itself is a contraction of the Latin phrase videre licet, meaning
Videre
being
licet.
permitted to
Meaning?
meaning it is permitted to see. It is used as a synonym for namely, that is to say, to wit, which is, or as follows.
That is different. That is to say is different. Am I right?
Yes, sir.
What you uttered, what you said in the beginning. Did you say that is, or did you say that is to say?
That is, sir.
Yes, because I am sure that you say that is. That's why I condemned it. Wrong, I said. That is to say, or namely, but generally we can say namely. So, videlicet is a Latin terminology, and its equivalent English is namely, and the abbreviation is VIZ with full stop, or sometimes without a full stop also. So, when you read, don't read blindly. Am I right?
Yes, sir.
So now the court will have the following powers, namely, that is viz or videlicet. Bullet 1, to send the decree for the execution of to another court under section 39 is the transfer to the executive petition to another court. Number 2 bullet, small bullet, to enforce the execution of a decree against the legal representatives of the deceased judgment debtor under section 50. If the deceased is no more, judgment debtor is no more, then it falls on the legal representatives of the judgment debtor. Either the legal representatives may be the heirs or any other person as decided by the court under section 50. Then third small word is to order attachment of a decree. When the attachment of a decree could be done?
In execution, sir.
When the judgment debtor is failed to pay the amount to the decree holder. Am I right?
Yes, sir.
That is the explanation. However, the court to which the decree is sent for execution will not have the power to order execution at the instance of the transferee of the decree, and the power grant leave to execute a decree passed against a firm against any person other than the person referred to in Rule 50 of the Order 21. Of course, there is a clearly mention over there to whom, against whom the decree would be executed. And suppose the judgment debtor is no more over there, it falls to the legal representatives under section 50, and to whom it is directed, it should be executed against him unless until it is not specified. Of course, not specified, no decree. When the judgment debtor would be there, definitely it will be specified. Am I right?
Yes, sir.
So now the powers of executing a court. What are the power of executing court? Oh, it is a gun. Okay. Now the section states the jurisdiction and the power of the court is executing a decree. An application for the execution of the decree can either be oral or written, but generally the court will ask only the written one. The court may execute decree as per the mode of the implementation prayed by the decree holder as the court deems fit. Of course, even the choice is be given to the decree holder also, or the court deems fit how the mode of implementation prayed, how a decree could be implemented over there. So the court may execute a decree as per the modes of the implementation. Who prayed? Decree holder prayed. Where? In his plaint, or as the case court deems fit. So, mode of executing a decree. By delivery of any property, movable or immobile, specifically decreed, hand over the property. How a immobile property would be handed over? Participants, how the
If it is
immobile
house,
property will be
handed over.
handed over by
If it is a house, yes, sir. If it is house, keys will be given as a symbolic possession, and if it is a landed property, paper, documents relating to that property will be given, and it will be transferred in the name of the transferee, sir.
that is getting the constructive position. By sale of the property, with or without the attachment of the property, it deems fit as a court deems fit. If the property is situated within the jurisdiction of the court, then it has the power to attach the property. Suppose the property is not in the jurisdiction of a court, then what will happen? The court will not transfer to the other court to execute the decree. And where the property is situated? Answer is
It,
yes.
yes, sir. It will transfer.
It can transfer. So by arrest and detention. However, this mode should not be exercised without giving a reasonable opportunity to the judgment debtor in the form of a show cause notice to why he should not be imprisoned or why his property will not be attached. In case if he pays, can you ask for the imprisonment? Answer is no. Is there any, both the payment and imprisonment would be there in the civil suit?
No, sir. Both will not be there. If you paid the amount, there will be no imprisonment, sir. If you fail to pay only, he will be imprisoned.
And who will bear the charges for the imprisonment?
Degree holder only, sir, in civil suits.
Yeah, in the civil code he has to bear it. But that fellow says, instead of giving the 20,000, give the 15,000 enough. He will waive the other thing. Am I right?
Yes, sir.
And the court will not interfere in that matter because he voluntarily waived himself. Am I right? Or he has to file another petition for waiving? Mean not
No, sir.
completely waiving.
It is at the discretion of the degree holder whether to ask for a total amount or to waive.
Or he will be satisfied with the partial amount also.
Yes, sir.
Okay. But whether he has to give in writing? Answer is
Yes, sir. He has to.
Yes, answer is yes. Execution by appointing a receiver. If any other mode apart from the ones mentioned in the class A to C needs to be used in the execution of a decree, then class E come into the play. Of course, when there is a dispute would be there, at that instant the court will appoint the receiver. And the receiver will see that all the formalities of the execution of decree will be fulfilled. I don't know whether the receiver will get some type of the token of amount as an honorarium.
Yes, sir. Definitely, sir.
Yeah, otherwise, how could he do such a thing? Yes, so jurisdiction and the place of suing. Section 15 to 20. Meaning of jurisdiction. The general meaning, jurisdiction is the power of the court to take the cognizance of an offense and to determine the cause of action. That means which area the court is having the jurisdiction to entertain. For instance, if a cause of action is in Khammam, then the Warangal court doesn't have the jurisdiction. Am I right?
Yes, sir.
So the area would be there to be covered, and that will be the cognizance of the offense will be taken for the action, for the cause of action. According to Black's Law Dictionary, jurisdiction means a court's power to decide on a case or issue a decree. That is the jurisdiction. The jurisdiction was defined in the case of Hirdaynath versus Ramchandra. The High Court of the Calcutta stated that jurisdiction may be defined as a judicial power of court to hear and determine the cause and adjudicate upon it, and who will make the demarcation of the jurisdiction? Is it the collector? Is it the High Court direction? Is it the Tahsildar?
Revenue people does not have power to decide the jurisdiction, sir.
Then who will
It will be
do
either
the
High Court
jurisdiction?
or Parliament by law, sir.
Is it Parliament by law? They do when the state jurisdiction is concerned.
For that, High Court will have power, sir.
The High Court
Court
make it
will
the
make
point, take into the consideration whatever the earlier position would be there, and whether it comes into the so-and-so area or other areas. By that they can decide it, yes, it comes under this jurisdiction. I don't know whether you know Garla. Garla comes under the Khammam or it comes under the Warangal. Of course, now it is the Mahabad. Am I right? Of course, you don't know, I believe. Certain things would be there, no? It is very funny because in what after crossing it, you will get the another jurisdiction. Means state will be changed automatically. Nagpur, you know Nagpur where it comes? Maharashtra. Are you following me?
sir.
Yes. In Maharashtra, how many law universities are there? National law universities? It is only the state, to my knowledge, having the 3 law universities. Number 1 in Bombay, or of course we'll say Mumbai. Number 2, Aurangabad. Number 3, Nagpur. National Law University of Maharashtra. Aurangabad, National Law University of Maharashtra. Nagpur and Maharashtra itself, Bombay itself. So the court to hear and determine the cause and adjudicate upon it where it falls under the jurisdiction of a particular thing. Of course, the area will be demarcated over there. Jurisdiction is decided mainly on the basis of, here it is given, it is mainly of pecuniary value, local limits of the court, the subject matter of the court. I don't know whether you know it or not. Do you know Toli Chowki?
No, sir.
In a way to, you are going to the high-tech city. Tori Chowki, the beginning, starting from the Nalal Nagar, Mehndipatnam, in the beginning it comes under the Langar House police station. Once you cross it, it comes under the Golconda police station. Because jurisdiction changes. Because once an accident happened over there, then I told that the accident happened in the beginning of the Tori Chowki flyover. Then they said, no, it will not come under the Golconda. The other side will come to the Golconda, but you have to go to the Langar House because that is the jurisdiction of the police, the town, police station. In the same manner, jurisdiction also, I think the same jurisdiction works for the court also. Because this so-and-so police stations will come under the jurisdiction of particular court. Then whatever the jurisdiction of the police station would be there, where a cause of action arises, that will be filed in the particular court. Am I right?
Yes, sir.
Of course, I am speaking about the criminal, is it not?
Yes, sir.
So the court, before taking the cognizance of the offense, the following points needs to be taken into consideration. Number 1, the pecuniary value of the suit means money value. Number B, the nature of the case, of course, is the civil nature or the criminal nature. Or the C, the territorial limits of the court. So depending upon that, it can be decided which court is having the jurisdiction to entertain the case. For instance, If election petition challenging it, in which court is having the jurisdiction to entertain it?
I think High Court, sir.
It is only the High Court is having the jurisdiction to entertain the election cases. So now it is not only the sufficient that a forum must be have an authority to deal with the matter of that, or that the court has a pecuniary jurisdiction, means money jurisdiction, or the court has a local jurisdiction, but the court must be competent enough to grant the relief in such a manner. In case, suppose the case is not filed in the particular jurisdiction, but the court may direct him to file in the particular jurisdiction of a court. Am I right? First, they will not entertain. They will say, cause of action arise so and so, so better file the case in the so and so court. But this court doesn't have the jurisdiction to entertain that area cases. Am I right?
Yes, sir.
Now, let us see the jurisdiction of a civil code, section 9. The word civil is not defined in the section 9 itself. According to the dictionary, civil right is a private rights and remedies that are different from the criminal and political. The word nature indicates the identity or essential character of a person or a thing. So, we can draw the definition of the suits of a civil nature means that the suit in a dispute relating to private rights and the suit must not be related to the political or criminal matters. It is self-explanatory, a civil right, a right infringed, the remedy available either among the individuals or between the individuals, but it should not have the criminal matter or the political. What is meant by political here?
That is election petition like that, maybe, sir.
It is generally regarding the even election signs. Suppose somebody challenge its symbols, that will not be entertained in the, it will be entertained, I believe, in the High Court only. Regarding the symbols, I doubt whether the district court is having a right to use certain symbol because somebody challenges it. But anyway, check it whether it's such a case would be there. Regarding the symbols I am speaking about, not regarding the challenge in the election. So now, the civil nature means the suit in a dispute related to the private rights. And the suit must not be related to the political or a criminal. Let us see what is the political case. Is it case or criminal case or political or civil nature? Political nature. Now, what are the things come under the political nature of cases? The knotty problem of extradition law. What is the political perspective crime? What is the politics in nature? Let us see that first one. The perspective is adapted that all crime is political, that the political aspect of social life influence the shape of our legal definition of a crime as well as the type and amount of a criminal conduct. That is one meaning of what is politics and nature. What does the polarized means politics? What is your understanding of politics? It is also a crime, is a political and the political aspect of the social life influence the shape or legal definition of a crime as well as the type and the amount of criminal conduct. Like, can you say political murder? Yes? A murder is a murder, whether it is a political or whether it is a personal. It doesn't make any difference. Am I right?
Yes, sir.
So, regarding the politics, if any offense would be there, then we can say it's a political in nature. But this is only the civil nature. So, the civil court shall have the jurisdiction to try all the suits except the suit which is impliedly or expressly barred. Of course, specifically mentioned, which is impliedly expressly barred. A suit which is related to the right to property or suit in which office is contested is of a civil nature suit. Notwithstanding that such right may depend entirely on the decision of the questions as to religious ceremonies or rites. Religious ceremonies rights, does it come under the family law?
No, sir.
Then which courts is having entertained the religious ceremonies? Is it the civil? Because you say, notwithstanding that such right may depend entirely on the decision of the question as to religious ceremonies or rites, and both the things come under the civil cases. It is immaterial
Maybe it
whether
is
the
civil.
fees to the office are attached or not, whether such an office is attached to a particular place or not. You know the Kerala case law or
The same
Purohit's cases in religious nature.
is,
It is a civil matter only. Am I right?
yes, sir.
Because some of the property of the temple will not be sold when it is under trust. Yes, it's a civil matter only. The suit which is expressly barred means the suit which is barred by any statute or any other law for the time being in force. Of course, statute bar 1. The legislator has an option to bar the jurisdiction of the civil court with respect to a particular class of suit, keeping itself with the ambit of the power conferred on the Constitution of India. I doubt whether the Waqf board cases will be dealt by the civil court or a Waqf board only decide.
No, the matters relating to religion does not come under civil, sir.
Uh-huh. Then which court is having the jurisdiction to entertain?
Only High Court is having
Achha,
the
we can
jurisdiction.
directly
Only High
approach,
Court, sir.
not the district court.
No, sir.
Mm-hmm.
Only High Court is having jurisdiction for election matters and religious matters, sir.
Any religious matter.
Yes, sir.
That means a civil court doesn't have the jurisdiction to entertain.
It is clearly mentioned in CPC, sir. Under
Okay,
section
okay. Then what about the Waqf board?
and
Waqf property.
it's also religious, sir.
So a civil court doesn't have any right to do. Either you deal with the Waqf board or file a Waqf board in the there is a council is there, no Waqf board, or you can file it in the High Court.
Only High Court is having jurisdiction, sir.
Okay, okay. Okay, thank you very much. The establishment of the tribunal has taken away the jurisdiction of the civil court. Okay, the establishment of the tribunal has taken away the jurisdiction of the civil court with regard to the subject matter that is allotted to the tribunal on the first instance. However, if any question related to law raised or any provisions act so created, the tribunal can be looked into by the civil court. Of course, once the matter is given to the tribunal, then at the time that civil court doesn't have it unless until something will become made it clearly, then the civil court look into the matter. The civil court has no jurisdiction over the matter in which the court under the Code of Criminal Procedure, of course, that is entirely the criminal matters. And the revenue court, even revenue court also not there. Is it there in the revenue court?
Revenue court means sub-collector office matters will be dealt by revenue court, sir.
Is it the collector will deal the revenue court?
Yes, sir. Sub-collector only, sir.
Okay,
Sub-collector
okay.
and revenue matters will be there is also like a court system appellant authority will be there, sir. First district collector will entertain and appeal maybe to collector, then to CLR, sir.
Suppose somebody is agreed by the collector decision, can he file in the district court or can he have to go to the high court?
No, sir. If he is agreed by the same, if sub collector gives decision, if any party is agreed, he has to approach collector, sir.
No, you are not happy with the collector decision. Then?
Then CLR, sir.
Mm-hmm.
Then High Court, sir. If he is agreed by the CLR decision, then he has to approach High Court, sir.
Okay, the High Court, you can directly apply. So here the civil court has no jurisdiction over the matters in which the court under the Code of Criminal Procedure, okay, Revenue Court has exclusive jurisdiction, and our matters dealt with the special tribunal, dealt in the special statutes. Of course, special tribunal means special statutes. Example, Motor Accident Claims Tribunal and Cooperative Tribunal, and those are dealt by the particular tribunal only, but not the civil court. So a suit is impliedly barred, which is barred by either the general principle of law or the general conduct of law. The basic purpose of the bar impliedly is that the court should not deal with the matter which causes injurious to the public or which is against the public will. That means it is clearly mentioned what are the cases will be come under the civil suit and where the cases will be barred by the civil. So that is very much clear here when it is given in the civil courts of practice. Is it the civil court of practice or civil procedure code only given? How's
Sir,
Is it given the civil procedure code or civil code practices?
civil court practices like that anyone civil rules of practice
The civil
is
rules
there
of
and civil
practice.
procedure
Okay,
is
okay. Civil rules of practice and criminal rules of practice.
yes, sir.
I believe that it is only made by a respective state high court.
Yes, sir.
Okay. In the case of PMA Metropolitan versus Morgan Marothama, the Supreme Court observed that the phrases used in the Section 9 has a positive and negative meaning. The earlier part has a wider sense, it covers all the matter of civil nature. On the other hand, the later part has a wider sense, it excludes the matter which is impliedly or expressly barred. So in the Section 9 have both the things of the CPC. The two explanations mentioned in the Section 9 expresses the legislative intention. What it casts an obligation on the court to exercise the jurisdiction for the enforcement of the private rights. That is one. No court is at discretion to refuse the matter which falls under this section. Of course, when it falls under the section, the respective court is having the jurisdiction to entertain such a case. It is a mandatory to take the cognizance of matter because the word shall, mandatory, is used, which means that it is a mandatory section. So shall, when it comes now, it is a mandatory and you should entertain it. In the case of Shankar Narayana Potti versus K. Sridevi, the Supreme Court held that civil court has inherent jurisdiction in all types of the civil matter as per Section 9 of the CPC unless the suit is expressly or impliedly barred. So inherent jurisdiction we can see in the 9 also. And such a thing inherent jurisdiction we will find in the, is it 110 or 111?
Inherent jurisdiction 151, sir.
It's a 151, okay. Because 152A amendment.
Yes, sir.
Okay, in the case of the state of AP versus Manjeti Lakshmikant Rao, the court held that for the purpose of constructing the test to determine the exclusion of civil court, it is necessary to look into the intent of the legislator to exclude the jurisdiction. So what is the intention of the legislator? Whether include the jurisdiction or exclude the jurisdiction, it will be clearly mentioned. It means that the test is done to determine whether there is any reason for the exclusion of jurisdiction, and if there is any reason to further find out whether such a reason is justified or not. Whether it is the inclusion or exclusion, by reading the context we can come to point. And what is the intention of the legislator at the time? Would the wider aspect will be covered or the narrower aspect will be taken. So although the justification is not subject to judicial review, once the court satisfies itself of the reason, then it needs to determine whether the act which excludes the jurisdiction provides an alternative remedy for the same or not. In case if it is excluded the jurisdiction, then what would be the other remedy available over there? So that would be taken into consideration. An alternative remedy must be in regard to such function which civil court must exercise in the absence of such exclusion, and would be empowered to pass any order which the civil court in similar circumstances would have passed. So when there is the exclusive one, there would be some alternative definitely. So it is the obligation of the civil court to see that such circumstances, then what would be the right way to pass the other remedy is concerned, solution is concerned. So in the case of the Bar Council of West Bengal versus A. Austin, the High Court of Calcutta states that when the statute which bars the jurisdiction does not provide an alternative remedy, then the jurisdiction of the civil court cannot be excluded. Suppose the statute is silent. At that instance, which bars the jurisdiction does not provide an alternative remedy. It doesn't provide any alternative remedy because the statute itself bars. Then the jurisdiction of the civil court cannot be excluded. That means it can give the alternative remedy. Is it correct? Inherent powers, we read it. When you want to change it, take to the parliament, it is taking its own time. To meet the end of the justice, the court will decide the alternative way. We studied it. Please watch my earlier video clips. So in the case of Balava versus Hasnabi, if the part of the suit is excluded from the jurisdiction of a civil court, then it is not necessary that the entire suit cannot be instituted in the civil court. Even a part of it also can be made when some party is excluded over there. In the case of Sri Panchnagar Parak versus Purushottam Das, if there are no express provisions in any statute, the court needs to look into the purpose, scheme, and relevant provision of the Act in order to determine implied exclusion of the jurisdiction of the civil court. Section 15 to 20 deals with the place of a sui. So, in one way, in another way, court is having some inherent power to seek the alternative to meet the end of the justice. Am I right?
Yes, sir.
Section 50 to 20. There are three kinds of jurisdiction to determine the place of a sui. Number one, territorial jurisdiction. Number two, pecuniary jurisdiction. Number three, subject matter jurisdiction. Of course, first two are very clear. What is the subject matter jurisdiction?
Just now we discussed only civil matters the power the court can entertain, sir. Like religious matters, election matter, those are subject matters are concerned. Only High Court has having the jurisdiction.
I appreciate
and lower court.
That is the exclusion of jurisdiction.
Yes, sir.
Whenever the suit is brought before the court, the first question is to determine whether the court has a jurisdiction to deal with the matter. If the court has all these territorial, pecuniary, or subject matter jurisdiction, then only the court has the power to deal with the case. In the case, if the court does not have any of the above mentioned factors, then it will be considered as a lack of jurisdiction or the irregular exercise of jurisdiction. When the court does not have the jurisdiction, decide the case and give a decision, then such a decision will be considered as void or the voidable depending upon the different circumstances. When it either the pecuniary jurisdiction or the territorial jurisdiction or the subject matter of jurisdiction does not fit in a particular court, then we can say irregular. If any court passes such an order, it is void or voidable. So that is a clear cut of jurisdiction is concerned. Now let us see the light on the pecuniary jurisdiction, section 15, in a broader way. Throw light on it. Every suit shall be instituted in the court of the lowest grade, competent to try it. The word competent denotes the court must have the power to hear the case with regards to pecuniary jurisdiction. The court lowest grade who has the jurisdiction with regard to the pecuniary value shall deal with the case at first instance. Means the lower court is having the first instance provided if it comes under the pecuniary jurisdiction. Lower court, what is the fine, what is the punishment?
जनगणमन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंधु गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभाशिष मागे गाहे तव जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे।
सारे जहां से अच्छा हिंदुस्तान हमारा। जय हिंद।